If you're thinking about creating an irrevocable trust, before you even get started, there are some issues that can pop up that you need to be aware of in terms of the permanence of the transfers and how they can be treated once you make those permanent transfers. So as a follow-up to the Common Estate Planning Trust series, this is a presentation for anybody who wants to learn about or consider transfers to an irrevocable trust, whether you be an individual, advisor, or attorney. This follows up on episode 210, where we covered funding a revocable trust during life or at death, and today we're going to look at some of the introductions to legal principles that can pop up when you make a transfer to an irrevocable trust, without getting into the mechanics, because you need to know the issues behind these transfers before you dive into the mechanics, which will come in a later episode. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. For today's episode, episode 211, this is part 3 of my series on Common Estate Planning Trusts. As I mentioned, we're going to just briefly introduce today the issues that can pop up when you make transfers to an irrevocable trust. As always, I remind you that this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. A little bit about me. I play two roles. I am an educator and speaker, so I provide tailored estate planning and tax education to the legal industry and the financial planning industry. So if you'd like to learn more about educational services, you can reach me at griffin.bridgers@gmail.com. If you're in need of estate planning services, I provide those through the law firm of Hutchins & Associates, LLC. So if you're in need of estate planning and you're a client in Colorado or Tennessee, you can email me at gbridgers@hutchinslaw.com. Now back to our presentation. So I'm going to give you a quick refresher on legal terms that we've talked about in prior episodes that are going to be relevant today. First is settlor. You're going to see that pop up through today's talk. That is simply a person who creates a trust and transfers property to it. Now, settlor has many synonyms. That person could also be called a grantor or a trustor or a trust maker, depending on the state, drafting software, circumstances, whatever the case might be. But all of those terms are interchangeable for the person who creates a trust and or puts property into it. Now, we've talked about the differences between revocable trusts and irrevocable trusts in prior episodes, but the big difference between the two is with a revocable trust, transfers to it aren't permanent, whereas with an irrevocable trust, transfers to it are permanent. So the revocable trust is one where the settlor, the person creating it, can take property back and change the terms at will by themselves without getting the consent of anybody. But with an irrevocable trust, once property is in it, the settlor can't get it back without giving property of equal or greater value in return to the trustee. And in this type of trust, the settlor can't do anything to change the terms on their own. They might be able to change the terms with the consent of the trustee and all beneficiaries, but that depends on the state, the circumstances, and a variety of other things. So irrevocable trusts are largely permanent. So in episode 209, we discussed a key difference between those, that the permanence of the transfer. So, with that being said, that permanence is going to really factor into the issues that pop up with an irrevocable trust. Because transfers to that trust are permanent, you run into underlying legal issues, mainly transfer taxes and asset protection and creditors' claims. Now, there's a lot of depth to those two issues, which may go beyond what you actually need to know, but we'll dive into those over a series of episodes here. But it's also ironic to also look at the parallels. Back in episode 209, we talked about how the goals of transferring to an irrevocable trust are often saving transfer taxes and avoiding creditor claims, so it makes sense that those would be the two legal issues we need to really analyze in depth if we're planning to make a transfer that's permanent to an irrevocable trust. So there's two methods of transfer, and we'll refine the mechanics of each of these across several episodes, but you can typically put property into a trust by gift or by sale. Now, that could occur during life or at death. Gifts are often thought of as lifetime transfers, but I'm going to use them also for the context of a transfer at death, because simply what a gift is a transfer to an irrevocable trust with nothing received in return, whereas a sale is a transfer to an irrevocable trust where you do actually receive property back from the trust in return. Now, those aren't mutually exclusive. You can have a transfer to an irrevocable trust that is both a gift and a sale. And really the difference is comparing the dollar value of what's put into the trust versus the dollar value of what's taken back from the trust. So for example, we have some facts here where a settlor has an asset worth $100,000 and sells it to an irrevocable trust for $80,000. So the settlor gets back $80,000 in exchange for this $100,000 asset. Now, since the settlor did not get equal value back, what that means is that that difference in price of $20,000 is extra value that the settlor has put into that irrevocable trust. So that $20,000 difference is a gift, and the other $80,000 will be a sale. Now, it's important to note here that the settlor could not have gotten back more than $100,000 from the trust on demand anyway, because it's an irrevocable trust. So the settlor can never get back more than what they're giving in or putting in, but they can put in more than what they're getting back. And that's the central key here when you're looking at gift versus sale or combining the two. So we're going to preview the transfer tax issue and the creditor claim issue. Like I said, there's a lot of depth to these, but the settlor who puts property into an irrevocable trust may have transfer taxes that can pop up. Those are often known as gift taxes for transfers during life or estate taxes for transfers at death. Now, one of the big misconceptions is who is liable for those taxes. Well, in the case of these taxes, we call them transfer taxes because they're imposed on the person making the transfer, the settlor in this case. The recipients of the transfer don't have to pay any tax on that. There's no transfer tax to them under federal tax law, nor is there any income tax to them under federal tax law either. Now, under state law, there could be, and it's impossible to really cover concisely the different permutations that apply to each state. Now, in most cases, a transfer to an irrevocable trust is going to be subject to transfer tax. The one exception to that is that there is a type of trust known as an incomplete gift trust, or ING, where the transfer may be permanent, but there may be no gift tax associated with it. Now, beyond that, if you have a sale to an irrevocable trust, you may have income tax liability for the sale component. Now, going back to our last slide, we mentioned that sometimes you could have a part sale, part gift. If you do, then that gift component could have a transfer tax that applies to the settlor. In the case of a sale to an irrevocable trust, there could be an income tax that applies to the settlor. The biggest difference is going to be one, is it a transfer during life? If so, if it's a transfer during life, you have to look to the income tax status of the irrevocable trust. One subject we'll cover a lot later will be the concept of a grantor trust. That's a trust, whether revocable or irrevocable, that the IRS essentially ignores the existence of just for income tax purposes. So a transfer to that trust would still be permanent, but the IRS, just for income tax liability, would treat the settlor as if they still owned the property that's been put into that trust. So it makes sense in that case that there would be no income tax, because even though the transfer to the irrevocable trust is permanent, for income tax purposes, the IRS just treats you as if you sold an asset to yourself, which never generates income tax, and a transfer to yourself never generates gift tax. That's going to be a central theme in our trust series. Now, transfers at the settlor's death will never necessarily avoid income tax, but a lot of the potential income tax could be wiped out because assets get a step up in basis right now under current law upon the settlor's death, which could wipe out income tax gain on the sale. There are some exceptions to that we'll dive into later, but generally that step up in basis helps you avoid income tax depending on the timing of a transfer to a trust following the settlor's death. Now, creditor claims, if you thought taxes were complicated, the creditor claims piece are even more complicated. So there's a lot of attorneys out there that specialize this. I kind of dabble in this area, but I don't do a lot of in-depth work with asset protection and creditor claims, especially for individuals who, as a settlor, want to protect their assets by putting them into a trust, but still having access to them. So we'll talk about that more as time goes on, but transfers to an irrevocable trust are often treated as gifts, as we mentioned, and those could cause creditor claim issues. So this only really applies to gifts. It's not necessarily going to apply to a sale, although the collectability on a sale, for example, if there's a note paid back, could factor into this. But usually what you're going to have is you're going to look at this from the perspective of a transfer to an irrevocable trust that is a gift from the outset, or that was intended to be a gift, or that ultimately becomes a gift because the settlor is not paid back for that transfer. Now, one common theme that I like to tell clients when we're doing irrevocable trust planning is that it's very easy to give protection against claims of the creditors of other people who are going to be beneficiaries of the trust. So that's an easy proposition to set up protection against the claims of their creditors against the trust property. But it's difficult to give protection against the claims of the creditors of the settlor. Now, there's a couple things that will factor into that. For beneficiaries, for them to be protected, assuming that, whether they are or aren't the settlor of the trust, the beneficiaries in most states are going to be covered by a spendthrift clause that will protect against all but a handful of claims, such as child support. Now, whether a spendthrift clause protects the settlor is going to be dependent on which state the trust is being administered in. So that's really the location of the trustee in general, but with some other factors thrown in. So, since most states are not going to protect a settlor under a spendthrift clause, you have to be intentional about finding a state that will provide that protection if you do want to set up a trust and protect the funds in that trust from your own creditors if you want to be a beneficiary of that trust. And regardless of whether or not there's a spendthrift clause in the trust, one thing that can affect the transfers to that trust by the settlor is if they are gifts, those gifts could potentially be reversed by a creditor of the settlor if, one, they create insolvency when the transfer is made, or two, if a creditor can claim that the settlor intended to defraud those future creditors of the settlor for claims that might come up but haven't quite come up yet. So really, the big picture item here is, one, the spendthrift clause. Who does it protect? It always protects beneficiaries if it's there, except maybe against limited claims. But whether or not it protects the settlor depends on the state that you're in. And you also have to look to what are known as fraudulent transfer laws. Do gifts to the trust allow a creditor to ignore the gift and take it back if the gift creates insolvency, or if the creditor can prove that the settlor was intending to defraud their future creditors by making the transfer to the trust? As always, if you have non-client related questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.